Our third and final form of intellectual property that we're going to talk about is patents. And patents are something that are given to people who create an invention. Um, Now, what's important to know with patents is these are gotten and given very early in the process in most cases. You do not want to wait until your product is designed, built, produced, ready to market before you get a patent. Patents are typically gotten in the planning phases of an invention where you have drawn blueprints up, created a scale model of what it's going to be, or a rough template of it, and you apply for that patent. And this is important because that patent protects your rights and gives you an exclusive right to make use and sell this product for a period of 20 years. The law says the first person to file the patent receives protection. So, especially if you are manufacturing something, you want to have that patent in place before you contract with a company to say, here, please manufacture my invention. Because if you don't have a patent, there's nothing to stop the manufacturer from going to the patent office and applying for a patent. Even though they didn't create the item, even though they had nothing to do with it, that they're simply just building it for you, they are going to have default rights for that patent over you if they file first. So before you share your invention with anybody, before you want to talk about it with anybody, you want to file for a patent to make sure you have that protection. And patents are not just given for brand new inventions, new ideas. I always use a stapler as the example in this. The stapler was given a patent maybe not hundreds of years ago, but a long time ago the first stapler was built. And that stapler was very similar to this stapler. It had the fulcrum, it bended, and it stapled paper. Now, over the years, we've seen improvements in the stapler. We've seen electric staplers. We've seen little mini staplers that you can fit in your pocket. We've seen those big, huge staplers that staple like 75 pages of paper. Each of those staplers were eligible for their own unique patent because they improved on or modified the task, the skill, the ability of the original patent. So you do not have to create a brand new item to get a patent. You can get a patent on an improvement on an item. And the other thing important to understand about patents, the product doesn't have to necessarily work in order to get a patent. You can get a patent for something that turns out is not a feasible item to go to market with. It could be something like the idea of a solar-powered car. And instead of putting a battery in the engine for it to be an electric car that you plug in, you're putting a solar panel on the roof, on the hood, on the trunk, and enough sun is going to charge the battery and the motor to run a car all day. And you may be thinking to yourself, yeah, in Phoenix that could possibly work. Put a battery in there that could hold something for 24, 48 hours. The sun might be able to do that. However, how many markets in the United States could you feasibly sell this solar-powered car to? And even if it worked and got enough miles range on a solar charge and drove fast enough and did everything it had to do, is it feasible to produce it where you can't sell it in 85 to 90% of the United States because there's not enough sun? year round. So patents are unique in the fact that they create and they protect a invention. They are good for 20 years, and that invention does not necessarily have to work in order for the patent to be approved. If for some reason, again, someone steals your patent, uses your patent, it is up to you to go to them and sue them in court to say you are infringing on my patent. And what is nice, what is good for people in that process is case law has been set up to allow for you to be financially benefited when someone is misusing your patent, infringing on your patent. You're able to get either royalties, which would be a percentage of each item sold that they sold, or lost profits. And what's neat about the lost profits with this is, if, for instance, I created an item that I'm selling for $200 per unit, and you stole my patent and you decide you want to just make a mess load of them and sell them for dirt cheap to blow me out of the market, and you sold them for $125 or $100 an item, and you sold a lot of them. When I sued you in court, I'm going to be able to collect my lost profits, not based on what you sold the item for, but based on the premise of what would I have sold the item for and what would my profits have been. So there's a potential in these lawsuits for me to be made fully whole again. Now, in many cases, the person who's stealing your product does not have all the money to pay you back that you want to be paid, but it is the court judgment is going to work in your favor and rule in your favor. Another interesting thing about patents, like I said to you, they do last 20 years. And patents also cover electronic devices, computers, technology as well. And what I would suggest to you, while in many cases that 20 years is fully used, if you think about it with technology, if any of you are old enough to remember what a cellular phone looked like in 2004, those patents are just expiring and just expired. Do you think any of that technology is still being used in a cell phone? Or if you think about laptops that were in the early 2000s, is any of that technology still in computers today? So technology-wise, maybe we don't need 20-year patents because the product changes so quickly and so tremendously, but we don't want to shorten that span either. So that is patents in comparison to trademarks and copyrights.